Any mention?
Wait, please, Your Lordship. Lordship, I pray for urgent listing of one matter. Lord, we'll be filing in the course of the day.
What's the matter about?
We are challenging the order dated 25/5/2026 passed by the BDO of West Garo Hills, my Lord, in which I am debarred from contesting the election of VEC.
Why debarred?
Only on the ground, my Lord, that an inquiry is pending against misappropriation of fund against my husband, not against me.
Yeah.
Nomination will take place on the 8th and 9th, Lord, Monday.
Tomorrow then?
Yes, yes, my Lord.
My Lord, I beg to mention item number 144, 145, 146, 147. These are connected matters, my Lord. This is a matter where we were regularized and subsequently revoked by saying that appointing authority was not a competent officer. This was in fact heard at length and referred to mediation. Mediation failed, so we are back, my Lord. So can you give me 2 weeks time, my Lord?
140?
144 to 147.
Okay.
My Lord, much obliged.
After 2 weeks is under. As is reported, mediation is not. As is reported that mediation has not been successful. This is matter for 2 weeks.
May it please, Your Honor, Your Lordship, beg to mention item number 151. 151, 151.
Yes, on behalf of whose behalf?
On behalf of petitioner, Your Honor, we have not received any instruction from him. So we need
instructions you are awaiting.
so that instructions to file some more thing, Your Honor.
You stand straight. Yes.
151.
2 weeks. Yes. No objection.
3 weeks time, Your Honor.
No objection, Your Lordship.
2 weeks. 2 weeks.
2 weeks.
Highly obliged.
One request of some.
May I please, Lordship, I beg to mention item number 49, 149, Lordship.
No objection, Your Lordship.
No, what's the matter about?
Lordship, petitioner was appointed as a fourth teacher, Lordship, with an undertaking that if any teacher vacate their post, petitioner will appointed as third teacher, Lordship.
That didn't happen.
No, Lordship.
Not
2 weeks, Lordship.
2 weeks.
Much obliged, Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 154, Your Lordship. I am for the petitioner. I am for the learned counsel of the petitioner, sir. Your Lordship, I pray for 2 weeks' time as the learned counsel is currently out of station.
Who's the counsel?
Mr. Sangma, sir.
Mr. Sangma? Is SP Mahanta leading in the matter?
LM Sangma, Your Lordship.
You've taken the consent?
Yes, Your Lordship.
Who is the other side? R. Kulni. You've taken consent?
Yes, Your Lordship.
What's your name?
Sami Rafael Nyota, Your Lordship.
Just record the name. Yes.
Obliged.
May please, Your Lordship. Lordship, I beg to mention item 152.
With the petitioner. Petitioners whom? You inform them?
We have informed Mr. Sen. Mr. Sen is for the petitioner.
What's the matter about?
It's a Chingate matter, whereby the HITO organization has been involved.
Why you want to take time?
We need some time to prepare.
Prepare what? Okay, 2 weeks. Yes.
Highly
Hello.
obliged.
Yes, make it quick.
Please, Your Lordship, I beg to mention item 153, Your Lordship. I pray for time, Your Lordship.
You for the petitioner?
Yes, sir.
Have you taken the consent?
No, Lordship.
Who's other side? You take the consent of the counsel of the other side, then you mention. Okay, you could take the consent, yes.
Okay.
Supplementary is item number 1.
Please, Lordship. Lordship, item 1 and item 2 pertains to the tender which has been floated by the tender for handling and transporting the food grains, Lordship.
Yes.
This concerns FCI department. Lordship, if I request, if your Lordship will take up item 2. Item 2.
What, there are two separate tenders?
Two different locations, Lordship. So the first item pertains to Nongstoin and second pertains to Tura.
What's the difference? Why you want to take up item 2 first?
Because Lordship, all the documents are relevant in item 2.
Yes, you serve copy, Mr. Singh. You receive copies?
Yes, I am there, man. Yes, my lord.
Who's your local counsel? No local counsel?
Mahadev Prasad. Mahadev Prasad is there, my lord. I think.
There's nobody here. Yes, anyway. Yes.
Lordship,
Yes.
NIT was floated on 11/3/2025, which is at page 20.
Yes.
This is for handling and transport of transportation of food grains, Lordship. This is from Mandipathar to Tura, Lordship, and this is for a period of 3 months.
Yes.
Now thereafter, Lordship, we participated in this tender and we were awarded a tender, Lordship, at page 131.
Yes.
That is appointment letter.
Page?
Page 131.
Yeah.
So after this appointment letter, Lordship, we commenced with our work, Lordship. Now there were certain difficulties that was faced. There were certain problems that had arisen at the Mendipathar way bridge and the railway head, Your Lordship. That will find place at page 133.
The contract is supposed to complete within?
Lordship, initially the
what was that period?
It's for 6 months initially, Your Lordship.
6 months initially. When was it settled with you? Date?
It was settled with me in the year on 28/3/25, Lordship.
When?
28/3/2025.
That was more than 1 year ago, yes.
Lordship.
Then period continues 3 months from there.
6 months,
6
Your
months,
Lordship.
okay.
Ad hoc
That
period
means,
is for 6 months.
28/9.
Yes.
Or 27/9, okay. Then?
Yes. Initial period is for 6 months. It's extendable after another for 3 months, Lordship.
Okay, 9 months, right.
Yes.
Then?
Now, at page 133, Lordship, this certain problem had arisen.
Yes.
So far as transporting of these commodities, Lordship.
Who's obstructing the lifting of the has concern?
Lordship, there's certain groups that have obstructed the Lordship. Kindly come to page 134. There's a type copy.
Okay, fine. Then what happened? This is 3rd June 25.
Yes, Lordship.
Okay, you started commencing. What is the?
This is the difficulty that we had faced, Lordship, because of
Now
this
what happened
reason.
after that?
Thereafter, at page 136 also, Lordship.
Okay, then what happened after? What your contract was cancelled?
Contract has been terminated. Terminated, Lordship.
Where is the termination?
That will find place at page 162, Lordship.
So they've retendered it to someone else.
No, the terms of the contract is that, Lordship, if the contractor fails to perform his contract, then another third contractor will be appointed by the FCI.
Right.
But that will be at the risk and cost of the petitioner, Lordship.
Given case, yes.
So here, Your Lordship, the demurrage charges have been imposed upon the petitioner, Your Lordship. Now, without any, which is in violation of the tender documents,
Where
Your
is the
Lordship.
tender? Where is it?
Lordship, kindly come to page. Kindly come to page 49, Lordship.
Where's the you have to be heard? Where is that?
Page 49.
Yes.
On top, Lordship, summary termination.
Yes.
Clause C, Lordship. They had invoked this clause.
The standard all FCI contracts. Yes.
No, the issue here is that, Lordship, after we have been issued this, we have been issued several notice, Your Lordship, for performing. Lordship, kindly come at page 148. We had submitted a detailed representation, citing the reasons why we are not being able to perform the contract.
Yes.
The representation is at page 148 and 149, Lordship.
Yes.
And as to why the charges imposed on us is illegal and arbitrary. Now thereafter, Lordship, at page 150, they have imposed us the liability on rebooking charges again on us.
What?
The rakes have to be rebooked, Your Lordship, and that liability have been imposed upon us. Now, as per the terms and conditions of the contract, Lordship.
1 second. Yes.
So these demurrage charges have been imposed on us arbitrarily.
Why it's notice is very clear. They have rakes have been informed to arrange trucks to remove the rice from the rakes. You have not done that. To make arrangements.
Immediately after
the rakes, then
because of certain reasons, Lordship.
What reasons?
At page 148 and 149 are the representations.
The thing is that is dealing with PDS.
PDS, Your Lordship. Now, Your Lordship, at page 52, there's a dispute resolution clause, Your Lordship, in the terms of the NIT.
Yes, Mr. Singh.
My lord, at this stage, notice may be issued. I will take instruction and file my affidavit in opposition, my lord.
We'll have a consider interim orders next date. Yes.
Lordship, only one submission, Lordship. Only a blacklisting order, Your Lordship, because they have terminated me and blacklisted me, Your Lordship. So far as blacklisting is concerned, Lordship, no notice was issued to me without granting me the opportunity of hearing.
Short affidavit, yes. But Mr. Emerald Nongtu and the council issue notice. Mr. B.K. Singh, the council present. We have all responded. Oh no.
All the respondent, my lord.
1 to
6.
Such no further notice called for stop. The petitions. Next petition is directed against against an impugn order dated 19/12/2025, whereby the contract of the writ petitioner was terminated, which the contract for lifting and supply of food grains for. What's the contract for? It's called handling and transport contract.
Handling and transport.
Yes, sir. Wherein the contract for handling transport of food grains. Where's the place?
This is from Mendipathar to
from Mendipathar to Tura has been cancelled. It has been submitted that the termination and also blacklisting, you said, and consequential blacklisting was without affording any opportunity to the petitioner. Mr. B.K. Singh prays that he will have to put my short affidavit and the pray for consideration of interim orders be taken next date. Yes.
Sure, I have one prayer, Lordship. No course of action, Lordship, because after the termination order was passed, Lordship, they have issued several notice of liability, Lordship.
Yes. When can you file affidavit? Depends on the time he takes. If it's a short date, no interim order. If it's a long date,
my lord, after 2 weeks, my lord, on 19, my lord, 19th of June, my lord.
It's a matter on 19th of June for an hearing. Stop. Then we just give him some protection till the next date. No course of action shall be taken against.
No course of action.
Yes, against the petitioner.
My lord, extra copies may kindly be served.
Yes.
My lord, extra copies may.
That is settled with the council.
Hello, Oblige.
The other one is for which part?
Oblige,
from Mendipathar to Nongstoin.
No, this other one.
In item
first repetition.
First repetition is from Mendipathar to Nongstoin.
And the other one?
From Mendipathar to Tura.
Okay.
Tura.
Item number 3.
Oblige, man.
That report is closed.
Item 3, Lordship, I'm praying for Passover, Lordship.
What is this matter?
This is checkgate matter, Lordship.
I think not before your Lordship. Your Lordship in the earlier occasion had recused the matter, your Lordship.
Well, we'll try to satisfy Your Lordship. Your Lordship has never appeared for the petitioner in this matter, Your Lordship.
Because
I don't know. All your concerns are confusing me. If
because,
you're not
no, Lordship. We have enforced the orders.
roving submission that you appeared in. Some bygone day you appeared.
Lordship, in fact, in the first
Lordship,
round, Your Lordship, they have already
or appeared in some division bench matter.
Lordship, after some time, Lordship, senior counsel is on legs. After some time, Lordship. No, Lordship.
Item number 4.
May please, Lordship. Lordship, this matter can be passed over for the end of the board, Lordship. This matter can be passed over for the end of the board, Lordship. The end of the board, Lordship. The other Advocate General is on legs for.
Advocate General is not concerned, yeah?
Lord,
In this case, which item we looking at?
Item 3, my lord. This Darbash no Mouthmore.
No, this is a different. This miscase number. Look at the submitted list, Mr.
My apologies, sir.
This is.
Your Honor, file an application for extension of time.
Where's the who's appearing? You serve copy?
Yes, Your Lordship.
Who's the counsel appearing?
KV Carlingdor.
Where's he? You serve copy?
Yes, Your Lordship.
Where's the... Okay, this case number 169-26. Sub in WPC number 89. 26 dispose of. This is an application for extension of time.
Your Lordship, please grant 2 months' time, Your Lordship.
For compliance with order dated 23/3/2026. MS Asim Yong submits that. What's your submission?
Your
Why
Lordship,
extension of time?
of 2 months' time, Your Lordship.
No, why?
Your Lordship, that clarification is required for both the parties, Your Lordship.
Yes?
Clarification required for both the parties, Your Lordship.
You please the case. What is clarification?
The matter has been examined by the CM of Hima Khairam.
What's the matter about?
Your Lordship, by order dated 23/3/2026, directing the applicant respondent number 4 to proceed with the inquiry and take decision in the matter as expeditiously as possible, preferably within a period of 2 months.
Okay. Yes, sir. Is submitted by learned counsel for the applicant that the extension of time is necessary in view of the fact that on the matter being remanded and taken up by the applicant as further clarification required both the parties, the extension is required. So it's noted that the opposite party has been served but none appears on their behalf today. This matter tomorrow.
Item number 5.
This matter you want pass?
Yes, my lord. My apologies again, my lordship.
After some time. Where's Mr. Paul? He's here.
Lordship, all respondents are here to enter appearance, Your Lordship. Respondent number 2.
8 and entering appearance. 8 and 9 school. What's the matter about, Mr. Kriam?
This is regarding where Your Lordship has passed an order directing with regard to the administration of certain Darbars, Your Lordship. No, what Mountmore. And
what's your prayer here?
Lordship, prayer is at page 19, Your Lordship. Page 19, Your Lordship.
Page?
19, Your Lordship.
You tell me what the prayer is.
Lordship, because what had happened, Your Lordship, despite Your Lordship order,
yes,
some individual had alienated the land, Your Lordship.
Okay. You alienated the land?
No, my lord. I'm the landowner. I have validly purchased the land.
You are 8 and 9?
Yes, my lord.
Yes, Lordship.
So I have no knowledge of any status quo at that point.
This is where from Jirang steamship?
No, Your Lordship, the jurisdiction of the Darbar was earlier fall within the Soyong. same shape, and then it was transferred to Jirang, and then later in 2024 it was later again transferred to Soyam, Your Lordship. Against that order, Your Lordship, respondent number 6 has come by way of writ, Your Lordship, and challenged that order, where Your Lordship has passed the direction, Your Lordship, the status quo should be maintained regarding to administration of land, Your Lordship.
Administration of land also.
Lordship,
status quo regard to administration of land also.
No, there's
my apology.
Where's the order?
Administration
Let's
of
see. Yes, short order. Yes.
page 29, Your Lordship.
Yes.
Lordship, operative is at page 32, Your Lordship.
Okay. So who's the British Council? Yes. You know this both of this matter.
Your Lordship, what happened was that the CM of Jirang, Your Lordship, the Chief of Jirang, when the first hearing was called for, he was unwell. And then after that, Your Lordship, an acting chief, they had sought time. Then acting chief was appointed. And after that, they had not taken any steps, Your Lordship.
The Jirang chief, he was unwell, so acting chief was appointed.
No, Your Lordship, he passed away.
Now the status quo is only with regard to administration of not hima nongwa mautamor, not with regard to alienation of any land or private land owners.
Yes, Lordship, but respondent number 6 who has filed the earlier writ petition, Your Lordship,
Yeah.
he claims himself to be the sorter of that particular area. He's the one wishing to pata, Your Lordship.
Is he a present? Are you paying for him? So you're appearing for whom?
But the reference is 9.
8 and 9. So you're appearing for Mr. Harwanlang?
My lord, for 1 and 2, my lord.
1 and 2.
I'm for 3 and 4, Your Lordship.
3 and 4. That means you're appearing for 8 and 9. That means 5, 6, 7 not served.
Lordship.
Yes. First note, your name? You're with Mr. Timaranga, Learned Counsel, that appearance on behalf of the respondents 8 and 9. However, office note indicates that status of service not been received with respect to the respondents number 5, 6, and 7. Stop. Mr. H. Kawalang, present behalf 1 and 2, and P.S. Nombri on behalf of 3 and 4. List after
2 weeks, Your Lordship. I'll file.
Yes.
With regards to the maintainability of the petition, maybe
yes, I missed the next one. Stop. But for this week's so and so enter appearance. Office note, but still service come to about you. Then Mr. H. Kawalang on behalf of Fund 1 and 2, and you also want to file anything?
No, Lordship, we're not filing.
And Mr. Marngar, he said,
Yes, ma'am.
on behalf of 8 and 9, freedom allowed to file a short affidavit before the next date. Praise allowed. Yes.
much obliged.
Just after 2 weeks for affidavit for service report on respondents number 5, 6, and 7.
Much obliged.
06.
Yes.
My please Lordship, I confess they are unable to file the affidavit today. Lord, yesterday the other matter was taken up and I was completely engaged in that file. My Lord, we have sent the other writ petition filed by the other suspended chief. Matter was heard yesterday and fixed the matter on Friday. Friday, may I just place in my Lord? Friday. Because of this I am unable to file the affidavit.
So you are appearing in other matter also?
If Lordship allow me 2 3 days, my Lord.
Lordship, we have received the affidavit filed by the respondent number 4, the acting CM. Can you have this matter listed tomorrow, Lordship, as this matter can be disposed of?
You try to put in by tomorrow. That's all on law.
My Lord, I'm unable to file the affidavit because of that only. Otherwise, we have prepared. We're prepared,
Mr. Changresa, yes.
We're prepared.
Take a chance tomorrow. We don't want to keep matter because it's creating a lot of
We really appreciate the urgency. Urgency.
Yes,
urgency.
we have to put matter
We want to
bed.
place on
This
record.
way or that way, it doesn't matter. We will hear submissions. Yes, Mr. H.S. Senior Counsel with Mr. Tita Kharapur, respondents number.
Respondent number 123, madam.
123.
123.
Praise that the matter be taken up on another date due to the inability of the respondents to put in the affidavit. So, respondent number 4 has also filed the affidavit stuff. In consideration of the prayer of the Senior Counsel, let the matter appear tomorrow, where attempt shall be made to take to dispose of the same. There is, we don't need to bring so much public.
If I fail to file, because of that only.
Yesterday there was a long hearing, very long hearing, and after hearing, one of the issues is, it is also in the pleading, in place of deputy CM, could I be appointed as the counsel? So this is the core issue there also, my lord. So I have
that has no relevance to this court. Have you placed order passed by this court before the other court when the matter was heard? Then you don't deem it fit to place that what have transpired here before this court for the other court. Then how can you help it? Then you want us to take cognizance of you don't deem it fit, Mr. Sen. I'm sorry. Yes, just.
Dealing item number 1.
If you want others, you are going to transfer it to the one bench only. You should place the order. If that is your contention, I don't understand how operating was.
Please, Lordship. Lordship, this is as per the decision bench order. There's only one issue.
Para 15.
Para 15. So in that case, actually, that
I didn't look at the file also.
Yes.
I just saw the name. I removed para 15.
Yes. Para 15, my lord. My reply is that actually there is allegation of that I have been terminated from service. So till now,
been terminated from service.
yes, yes. The report, the order was passed on the basis of the report filed by the department because they have filed a long report. Now, with that particular issue, they said, in the report says that I was terminated from service. So the state respondent till now they are not able to supply or furnish the copy of the termination letter. I'm denying that I have not been terminated from service.
You just been given some little room to breathe by the division bench. Okay, that report, because you said the only contention you gave for the division bench is that I was not heard when inquiry was taken up. Correct? No, sorry, inquiry was not supplied to me.
Yes,
already you were part of the inquiry.
Yes.
Now this inquiry was a court, directed inquiry to be done. Correct? They found that you are inquiry. In the wrong side of everything.
No, yes, that inquiry report was submitted later. I was even punished.
Yes, to the
yes, I've gone through the inquiry report also, my lord.
To the court.
Now, even in the inquiry report,
the court says, and what did the division bench say?
Division bench, yes, lordship. It says only yes, para 12. It says only the in view of the opposite direction, the proceeding contemplated in para 15 bracket 1 of the impugn order shall remain stay and shall abide by a fresh decision to be taken in this regard at the time of disposal of the repetition. However, in the event of no affidavit taking exception to the inquiry report is filed within the time frame stipulated in this order, the impugn order shall revive without any further reference to this court. So, in view of this, I have filed a reply.
You filed a very long reply, but only to it should be limited to paragraph.
Yes.
Then.
Yes, only to the with regards to the issue of the para 15 bracket 1 also I have stated, lordship, where I said that I have never been terminated, and in the inquiry report I was supplied the entire inquiry report. Even in the inquiry report, they have not enclosed the termination letter. If that case has been that,
is that correct, Mr.
Yes.
Shulai? Is that been enclosed?
No. No, your lordship, that is.
The question which can be posed to my friend.
Let him finish.
Attending the school or not?
Let him finish, your lordship. We will reply accordingly, your lordship.
Yes.
We will reply accordingly, your lordship. So my only submission is only with regards to termination because
your content before I was not terminated.
Yes, I'm not terminated. That's why I'm saying that as of now, till now also, even in the inquiry report, they have not furnished the copy of the termination letter. If they have furnished the copy of the termination letter, then I may have taken a different course of action or yes, because different view now.
Yes, Mr. Shulai.
Now they have to give me the at least the termination report.
Yes.
They should not argue on the other aspect, because this is the argument only on limited to the paragraph 15 of the Brigade 1. The Lordship is very clear. So they don't want to, should not go with regarding the submission of fake document. That document that was that is not the issue. Only the issue is that I have stated clearly that they have not terminated.
The only thing is that you say, the division bench said, the only contention is that if 15.1 is implemented,
yes,
because you're not furnished with inquiry report,
yes,
then because 15.1 has what has directed for proceedings to be taken up against you, both criminal and civil, correct?
Yes.
So that's the only thing.
Yes.
So where have you said that? Now, only thing is that now you're trying to stretch it to the termination.
Yes, it says the 15 order 15 says, my lord, just I will read it also. In my appeal memo, I have enclosed the order which I have appealed the order dated 24/11/2023. I will just go to the para 15 of the judgment, the last para. It is the page 14 in my appeal petition. I have enclosed it.
We call for the records. 64.
In appeal 36 of 2025.
Majors, where have you made that?
The just will go to the para 15 and Brigade 1
of your
of my read appeal actually. In the record, you will be there, my
yes, 15 para 1 of your.
Yes,
your
just will read it. The 15 para that the relevant page actually. They have been enclosed in the on top of that one. I have enclosed it, so it will be there in the. Judgment.
Yes, in the writ appeal, which page?
In the it is the running page 130. On top of that appeal, I have enclosed the judgment, my lord. It will be
just on top of the appeal. Okay, 15.1, yes.
Yes. So may I read the para 15? As Sri Nurul Amin has been found not to be a teacher occupying a sanctioned post and terminated from service on 9 February 2021, as per resolution of the same date, and further having indulged in destructive activities such as filing of fabricated document which has been dislocated,
which has dislocated the functioning of the school.
The functioning of the school as recorded in the report. The appropriate action as per the relevant rule and in accordance with law, both civil and criminal, shall be initiated against him by the managing committee as well as by the district school education officer, West Garo Hills, within a period of 8 weeks from the date of this order. So here I say that they, in the report, they have stated that on 9 February 2021 I have been terminated. So I'm only
saying that there was no order on 9 February 2021.
Yes, they have not punished. That is
we limit that to that. Yes,
that is only to that. Only that is my submission. I'm not going to any other issue. If they submitted a copy of this, or
yes, Mr. Shlai,
then
may it please your lordship.
In the inquiry is.
Lordship, kindly have page 19, para 9 of the judgment passed by the division bench, your lordship.
Para 19 page?
Page 19, your lordship, paragraph 9, your lordship.
Page 19?
Page 19 of the miss.
This is my reply. He's referring to the reply.
The reply to the report of inquiry.
There I have enclosed
in before the division bench.
In lordship, no, in writ petition number 264 of 2020.
Where is the affidavit?
19.
You got in the affidavit.
Lordship, that is the reply to the that is the reply to the report of the of inquiry, Lordship.
No, you kindly see. I'm getting confused.
It is filed in writ petition number 264 of 2020, Your Lordship. Let me assist Your Lordship. Which one? 264. Oh. Inquiry report is here. Page 19. Please find out that. Lordship, that is the reply to the report of inquiry, Lordship. Lordship, kindly have page 19, paragraph 9 of the judgment of the division bench.
Yes.
Say,
yes.
Then, Lordship, before going to that, if Lordship kindly have paragraph 15 of the judgment passed in those series of writ application, Your Lordship. Lordship, yes. Lordship, kindly have paragraph 15 at internal page 14, Your Lordship. As such, Your Lordship, I'll just go to Your Lordship. Shri Nurul Amin has been found not to be the teacher occupying a sanctioned post and terminated from service on 9/2/21 as per resolution of the same date, and further having indulged in disruptive activities as such filing of fabricated documents which has dislocated the functioning of the school as recorded in the report. Appropriate action as per relevant rules and in accordance with law, both civil and criminal, shall be initiated against him both by the managing committee as well as by the district school education officer, West Garo Hill District, within a period of 8 weeks from the date of this order. Then, Lordship, kindly have the page 19 at para 9, that is the judgment of the division bench, Lordship. Yeah. Lordship, it says, Your Lordship, in view of para 15(1) of the impugned judgment, which after accepting the report has directed proceeding to be initiated as per the law against Shri Nurul Amin and is likely to visit the appellant with civil and criminal consequences, in our view, the appellant is entitled to respond to the said report before any decision could be arrived at against him in the writ proceeding. On the limited issue that the appellant was entitled to an opportunity to file an exception affidavit to the inquiry report and argue the matter in relation to the finding against him in the we allow the appeal and set aside the impugned judgment only limited to direction contained in paragraph 51. Then, Lordship, we make it clear that we have not gone into the merits of the inquiry report, Your Lordship. So, Lordship, the report of the inquiry has not been gone into by the division bench, Your Lordship. Then, Lordship, in my humble submission, Your Lordship, can, the liberty is there to relook at the report of the inquiry. Lordship, then, what is the
court's already examined the inquiry report? The view can't differ from early view. Only thing is that he said, as I didn't have inquiry report, so he wants to make a representation against that para 15(1) only. 15(1), whereby we said that action should be taken against him.
Lordship,
both civil and
what is 15(1), Your Lordship? What is 15(1), Your Lordship?
That you've seen.
Termination, Your Lordship. Termination, disruptive activities, and filing of fake documents, Your Lordship.
That's what
filing of fake document, Your Lordship. Then, Lordship, kindly have.
If you have not done those things,
Lordship, then Lordship, kindly have page 3.
No, what this court wants to see is where the termination order dated at 21st. That's the only thing. If that is there, that ends the matter.
Yes.
Is it there an inquiry?
They have not. It's not there.
If it's there, it's over. We'll close the matter today. Yes.
They have not,
because even the only want to set aside only that finding paragraph 5(1) to allow you to represent.
Not only on termination, Your Lordship. Disruptive activities. Yes. That means three things.
5(1), three things. Yes.
Yes.
He's then allowed this matters to send back here to allow petitioner just to present his case against.
Para 15(1), Your Lordship. Para 15(1), Your Lordship. In 15(1), what this Honorable Court has recorded,
termination order then?
Recorded, Your Lordship, is the termination order,
yes.
Termination, disruptive activities, and a filing of fabricated documents, Your Lordship, in a writ petition.
That termination order, my lord, I have checked the report.
It's not there.
It's not there. Report was submitted on 21st July 2023.
Where's the resolution? Of 9 February 2021.
Just a minute, Your Lordship.
They have not given the resolution also.
See, the inquiry report also. Not only that, even in WPC 119, you produce a fake document.
Lordship, yes.
13/5/21.
I'll come one by one, Your Lordship. Where is that? This fine.
The resolution, the same resolution and termination letter.
One person has created all this above. You ever think about the students who are studying the school?
Now, I think, my lord, the school is
doing. Do they think about the students, the well-being of the students?
The school is going as far as of now is going smoothly. Only because.
What's the results? Last results of the school?
Because now I am no more in school, my lord.
Just a minute, Lordship.
It's not there.
It's not there, no?
It's not there.
Who's appearing for the managing committee? Then pick out a resolution. Because it's recorded, I think, in the inquiry report.
This is the resolution.
He has filed a case on behalf of the managing committee. He has filed. Now he has made a managing committee as a party, but they have instructed me to appear present. And I am also appearing for the candidate, person who was appointed in 2 days.
Just a minute, Your Lordship.
No. On 9 February. Let's see. February 2021. 9/20.
You come to inquiry report, Mr. They have not. The decision bench not seen inquiry. Come to page 13 of inquiry report. You read the last paragraph, which is paragraph 1. You just kindly read it. You read it, Mr. Shulai.
Lordship,
the detained repression any further. 13, yes. You read it.
It is discernible that at the root of the problem of the so-and-so school is a claim made by Shri so that he is the head teacher, being the founder teacher and also the language teacher. This controversy erupted on account of new NCTE norms that mandate that in SSA school there could be one language teacher, one science and mathematics teacher and one social science teacher. When appointments were made after the school was brought under SSA in the year 2010 and thereafter when Shrimati so-and-so was appointed as language teacher in the same year in the place of Shri so-and-so, who resigned, and later Shrimati so-and-so and mathematics teacher come head teacher by so-and-so resigned, Shri Nurul Amin never raised any grievances at that stage. Apart from putting up a claim, much later so-and-so on merit has no case as he was never appointed against the sanctioned post. So he was never appointed in the sanctioned post, Your Lordship. Then a challenge, if any, should have been made by Shri while initial appointment took place about 7 years ago and not at a late stage. which if entertained will unsettle a settled position. From the circumstances, it can be clearly seen that Shri Nurul Amin became active after he could manage an allegedly illegal approval order from joint DMC Shri so-and-so, and when Shri Mati so-and-so joined the post of so-and-so. So further, it may be mentioned here that for information that as record revealed, Shri Nurul Amin never responded to any inquiry to establish his position other than the one conducted by joint DMC Shri Mati so-and-so. It is also seen from record that Shri Nur was found to be embezzling SSF1 and did not either take steps to reply to the allegation nor justified his course of action. His action during his term as convener has further exacerbated the situation. At the same time, that terminated the service allowed him sufficient opportunity to reply and justify his alleged deed of omission and commission. Further than replying to the show cause notice issued to him by the then SMC, he chose to challenge the authority of the official also who instituted inquiry and was not cooperative in the inquiry proceeding, thereby raising sufficient suspicion that his act of omission and commission was brazen and against the rule. The act of submitting even fake documents to substantiate his claim make the matter serious and does not leave any shadow of doubt that Shri Nurul Amin has been desperate in his motive and his claim are unjustified. The portion sanctioned post of language teacher is also clear from upon perusal of the various resolution of the initial.
That's enough. So, Mr. Sangma,
then
you don't have a qualification, you obtain fake approval. How are you standing here now and still?
Then if Lordship kindly have of the same reply, Your Lordship, at page 3, para 1, I, Your Lordship.
Very colorful character. That's why the earlier counsel quit being the lawyer of this person. Must be because he is represented another person who filed appeal. You filed appeal.
Yeah,
actually,
you
there was
when he filed appeal. Were you the
filed
counsel?
appeal.
No, were you the counsel?
This is
just a question. Lordship. Were you the counsel when the appeal was filed?
No, first appeal I was not there.
Appeal for appeal. Yes. Were you the counsel?
No, I'm not the one.
That answers your question.
Because this is the third time I filed. Yes.
Filing where? The appeal?
No, first they filed appeal against the order. Then it was dismissed something. Then again asked to file revision. Then after revision only I filed an appeal. I'm the third one. Advocate.
You're a third lawyer.
Fourth lawyer.
Fourth lawyer.
Fourth one. Yes. Last one.
You're the last one. You're very confident. Yes. Last one will put an end to the matter also. Yes. So what do you want to do?
No, only saying that only submission that they let them produce the termination letter. And the resolution.
You made that in your challenge to the report.
Lordship, the judgment.
The report I have stated in the. That is a page 10 I have mentioned regarding termination. Of my affidavit. And regarding the facts document I have page 8.
Oh, those documents are not going to go there. They all fake.
Says only the termination that page 10 on point 12 I have mentioned that I have not been terminated, neither served the copy of the termination letter and also the resolution.
You never raised why did I make the Additional Advocate General read those paragraphs? To show your conduct. That 7-8 years ago you never challenged anything. You knew that you had no case. You kept quiet. You're never upon a sanctioned post. You don't have the qualifications. Then you obtain some illegal approval from some corrupt official. And after that you start raising your head and created this entire trouble in the school, whereby duly appointed teachers also their services were interrupted, which forced them to come to court.
Then,
what should we do with this kind of person?
Lordship, I'm not denying that.
No, you're a counsel only. You're presenting your case. We understand that. But the thing is that what should we do with that kind of person? This kind of person. What would be your idea?
Deserve to be fixed for responsibility. Punishment.
See, that's very fair. Yes.
Lordship,
Page 10.
Lord.
My lord, coming to page 10 of the inquiry report of the affidavit that my friend has filed. Page 10, para 12, my lord. We'll close this matter today. Yes. The second half, my lord, the sixth line. The sixth line, my lord. The inquiry report was never enclosed the copy of the alleged termination order.
We're reading page 10.
Page 10, my lord, para 12. Yes.
Yes.
Para 12, my lord, for the inquiry report. If my lord find it, my lord. The inquiry report
Yes.
is the sixth line. The inquiry report was never included the copy of the alleged termination order. Therefore, the statement made in the inquiry report is totally incorrect and unsustainable. Now, if that is the case, what he is claiming, my lord, he is challenging the inquiry report, which was done by my lord, after the intervention of this honorable court, my lord. And that inquiry report is not under challenge, my lord. It's mere an affidavit. He could have challenged that inquiry report, my lord, in a subsequent proceeding. And even the division bench has not found, my lord, there was any wrong in the inquiry report. There's only this affidavit is there with regard to challenge inquiry report. That's all. Yes. Okay, take down. Yes. This matter has reappeared before this bench on being remanded by an order dated 23/10/2025. Passed in writ appeal number 36 of 2025. The Learned Division Bench by a set order was pleased to limit the issue on remand. No. Which is contained in para 9 of the judgment of the court, which is reproduced here and below. Stop. A perusal of the above quoted paragraph will show that the remand was based on the fact that on the basis of the report, on the basis of the earlier order of this bench, which had accepted an inquiry report, proceedings were directed to be initiated against the petitioner, for which he had not been given adequate opportunity to represent against. As such, this court today will examine this limited aspect of next paragraph. Thus, this takes the court to para 15(1) of the order in question, which the petitioner has taken exception to. Stop. The said para, which was where's the order?
That's ordered 24/11/2000.
In your affidavit.
In appeal, my lord. In clause.
Where's the
that
order
order?
you gave just now?
Appeal petition.
Where's the copy order you gave just now?
You can take it this order.
Single bench order. Yes, yes. High Court for inquiry. You're given the copy, right, Mr. Sangma?
Yes, I have included in my appeal.
Oh, yes. But no, it's here.
It will be page.
Huh? Come on. Talk of dictate no Pulian does it. Thus this code. Tahu juga tu. Bukan semata. Nang umum tan just. Let's take the code of the order dated 24/11/2023.
Yes.
Yes. The said para, which was passed in LPC number 264/2020. The said order, which was passed in 24/11/2023 in WC 264 and other connected petition, is also reproduced here and below. Stop. Next paragraph. In this backdrop, Mr. P.T. Sangma, in the backdrop noted above, therefore, this court to determine the issue finally, as per the submissions which have been tendered by the parties. Next paragraph, Mr. P.T. Sangma, Learned Counsel, submits that in para 15.1, is this? No, this is a wrong order. I don't know. This is not right order.
In appeal one.
Not appeal. In appeal, where is it? Appeal.
In the appeal 159, page 159.
Appeal, no. Single bench order was passed 15.1. Where's the para 15.1? Get the appeal. I mean, it is below. It's not that date. No. It's 264 dated. The date is different. The appeal. Page
159, my lord.
Yes.
In appeal. The relevant.
Which order dated.
Order dated
24/11.
Lordship.
Correct.
Lordship.
Pass in 264 and other connected matters. Okay. Mr. P.T. Sangma has submitted that in paragraph 15.1 itself, reference has been made to a resolution of the Management Committee dated 9/02/2021, by which he was terminated. The only submission is that he said resolution.
Yes, they said resolution.
Copy of the resolution was never supplied.
Yes, copy of the resolution and the termination letter.
The petitioner. As such, he submits. As such, he says that due to non-supply the resolution, proper reply could not be.
Yes.
Could not be
done.
Could not be made by the writ petitioner. Stop. In reply, next time, Mr. Andy Shulai, and then AAG has submitted that paragraph 15.1 of the judgment dated 24/11/2023 is not limited only to the question of the resolution, but the findings contained therein, findings contained therein, which have been revealed in the inquiry report, such as the petitioner having indulged in disruptive activities, filing of fabricated documents, which have dislocated the function of the school, for which this court had recommended that appropriate action be taken against the writ petitioner. Stop. He therefore submits no cogent ground having made out the order dated 24/11/2023, which has also not been interfered with by the revision bench. Apart from directions to pass orders on the set above noted issue, having not been interfered with by the revision bench, except for the issue concerning paragraph 15(1), the incident petition be dismissed. Yes. Next by Mr. SD appearing for the management committee.
What was the private exponent, my lord.
And
my submission is this, my lord, that if he is aggrieved with the inquiry, my lord, an inquiry copy was not submitted, my lord, he could have challenged the inquiry report. Now the inquiry report is before him, my lord.
Yes, Mr. SD, who appearing to the management committee of the concerned school.
If I can. He was appointed as a Hindi teacher, my lord.
We're not going to go there.
No, I'm just submitting, my lord. That may not be recorded, but he was appointed as Hindi teacher. Subsequently, he was terminated, my lord. The termination order is also not under challenge.
Yes.
Now he is claiming that the termination order was not supplied to him.
Has submitted that the writ petition was terminated Hindi teacher, and the same was never challenged, put to challenge. And further, if the writ petitioner harbored any grievances against the inquiry, wherein a copy had also been supplied to him, he was at liberty to take appropriate action. So he therefore submits at this late stage. The petitioner is entitled to any relief as claimed. This court, having examined the order passed by the Honorable Division by the Honorable Division Bench, and also the early proceedings that have transpired before this court, notes that the central issue concerning the central issue that had led to the inquiry report was due to the fact that this court at that point of time, in order to get to the root of the matter and the presence of had directed for inquiry to be conducted. Stop. At this stage, it would be expedient to quote the relevant findings, extract of the findings, which are contained at at page 13 to Page 13 to page 17, bracket para 8. Stop. Without further prolonging the matter, taking into consideration the findings of the inquiry report, taking into account a fresh perusal of the inquiry report, and also the limited challenge made by the writ petitioner on to the non-availability of the resolution, this court finds no reason to reappreciate or find no reason this court finds that the petitioner is not entitled to any further relief. As such, the writ petition is only disposed of. It's expected that the early orders contained in the orders dated
24/11/23, Your Lordship.
Yes, pass and this should be complied with by the authorities. Yes. Stands closed in this court.
Item number 2.
Must please proceed.
Number 2.
Number 2, same, Mike.
Same, Your Lordship.
In both, Your Lordship.
Order pass and so on.
We will provide, Your Lordship. Yes.
No point prolonging it, Mr. Sangma. You tried your best.
Next. 3.
Yes.
Please, Your Lordship. Lordship, we've filed the affidavits in all the leading matters.
You filed all?
In the leading matters in all the... In the leading matters before all the departments, Lordship. Lordship, I've prepared...
Where's the list of leading matters? You're supposed to make it department-wise. Where's that list?
Lordship, the respondents. Respondents, Lordship.
Oh, Lord, I've prepared a chart.
The department-wise? This lead matter isn't...
The department
is agriculture weaving.
Yes, my lord. Then number 2 is G&M Health.
No, this one is G&M Health.
Then 3 is Health.
General Health. No, G&M
Agriculture
Health.
and Water Resource. My lord.
G&M or Health?
G&M Health.
This no. This number 3.
3 is Health.
What post?
My lord, this is a post.
Number 3, these are paramedics, Lordship.
Paramedics.
Yes. Right there then.
My lord.
Paramedics. And then?
And then
agriculture.
Number 4 is agriculture, my lord.
Serving as?
Agriculture.
You know, chart, yes. I just want the post. Agriculture, they're serving as?
These are all ministerial posts, Lordship. Ministerial posts.
Ministerial.
Ministerial.
And then
5
water resources also ministerial.
Ministerial.
Only health there's no, because what happened? Some matters have to be closed.
No, Lordship.
Yes, the other orders were passed.
Not closed, Lordship. Because so far as health department is concerned, Lordship, there are staff nurse also. So far as staff
some
nurse,
matters orders were passed by the government regularizing them.
in those matters, Lordship, staff nurse.
Yes.
They have conducted the screening, Lordship. Now that is still pending with them. No final order has come till date.
No, but they've been gone through. Then that SOP won't apply to them.
That the state has not clarified, Lordship. They've only issued a notification calling us for producing the necessary documents. That has been done, Lordship. Now thereafter, no steps have been taken by the government. It's still pending till date with the government.
Is that correct?
It's correct.
Your Lordship will see the chart, my lord. Your Lordship kindly have the chart, my lord.
You have the chart, yes.
Chart page serial number 2, my lord. Your Lordship will see verification was conducted on the process is going on. My lord, what we can do is, my lord, we have filed the counter affidavit in all matters. And my friend can file rejoinder, and Lordship may have it for hearing, my lord. And so far as we can segregate the G&M Health Department separately, my lord.
Right. Water resources, that's it. And last?
Yes, my lord.
Animal husbandry.
Ministerial staffs.
Okay.
Yes.
Then the other one regarding that. Oh no, that's different. That age 65 to.
No, that is RCW. That's a different matter, Lordship.
Casual worker, my lord. Casual worker issue.
That's a different matter.
Yeah, different matter. Different matter.
My item number 71, 72, 73, you feel that after they have not filed their petition. It's a head
No, they
department.
file in all the lead matters. One affidavit suffice.
And we'll supply the copy.
You supply copies all the
They
yes.
will supply the copy to us.
Whether RP General submits that in these batch matters, affidavits have been filed in all the lead matters. Stop, Mr. M.L. Nongpur, you want to file rejoinders?
Lordship will examine. So far as the health department is concerned, I'll just examine the affidavit, Lordship.
Will you file rejoinders with others?
I'll verify, Lordship. I'll
Mr.
just.
M.L. Nongpur, learned counsel appearing for the petitioner, Mr. P, in the petitioner is also Mr. P.T. Sarma.
My lord, I can.
I'm allowed to.
Yes, if required, we'll file there.
To peruse the affidavit and to file rejoinder if necessary. Within
2 weeks time.
by 2 weeks, yes. Copies of the affidavits we made over to you. You take copies to Mr. P.T. Sangmai. Yes, after 2 weeks, yes, for further orders.
This one.
Otherwise, should report for hearing or we dispose of admission hearing stage?
Lordship will put it for admission hearing. We can argue the matter.
Okay.
No, that is a.
Your LPC number? Number? It's not here in the chart.
It's not there, Lordship. Lordship, what has happened during the pendency of these matters, Lordship, in one of the department, they had floated an advertisement, Lordship. So that is the
It's
repetition.
not connected to these matters.
It's more or less connected to the SOP matters. Because the same petition
We'll take 151 separately. Yes, sir. This will cover item number what to what?
32115. 32115, 132 and 133.
32115.
132, 133.
What about then MS Karanlang's matter?
Just a feature.
So far as that matter is concerned, it's connected with 114, Lordship.
114. Just for Suja.
I'll just provide the main petition. Chesterfield. Lordship is connected to item 177. Item 77.
WPC number?
77.
WPC
sorry,
number?
555.
555.
Item 77, Lordship.
Okay.
Now this is these are the SOP matter, Lordship.
These no, the sericulture.
No, these sericulture department.
555 sericulture department.
Yes.
That's sericulture also.
No.
No, connected.
So Lordship, I'll just clarify, Lordship. 555 was filed by the petitioners challenging the SOP, Lordship.
9 petitioners given.
9 petitioners. Interim order was passed by this court. Now thereafter, Lordship, because of some other proceedings pending before this court in the other petitions concerning different petitioners, Lordship, in that case, the order was passed that the government can take steps to advertise the post, Lordship. Now, on that account, Lordship, advertisement have been floated by the MPSC, Lordship. So against that advertisement, we had challenged in item 115, Lordship.
Okay. Then an item 115 is yours. WC number?
3 of 2026, Lordship.
File all these matters. Then one paragraph, however, with regard to WC number 115, WC number
3 of 2026.
3 of 2026, bracket item 115 today. MS BF Karanlang appearing for respondent number 6, please be given further 2 weeks time to file affidavit.
It'll be not necessary because
Letter?
if 555 is allowed, then this matter goes.
Just after 2 weeks.
Lordship, there's only one issue. I don't know if the learned EG has noticed. Lordship, there are other departments as well, Lordship, which concerns the landowners, Lordship. Landowners, even those posts have been considered.
I mean, those people are given employment by donating land.
Yes, Lordship.
How many cases are there?
Lordship, so far those cases are concerned. That will be from item number 108, Lordship. 107, 108, 10. Item number 107, 108, 109, 110, 111, Lordship, and 112, and 111, Lordship.
107 to 1.
Affidavit. Ms. Amnongpur has also submitted that certain other matters appearing in items 107 to 111 today have not been addressed by the
Whether they'll be filing affidavits or not, my lord.
Then Advocate General submits that appropriate steps will be taken. Just after 2 weeks. Yes.
Lord, they are, I'm sorry, my lord, I was in the other.
Doesn't matter, it
Lord.
takes steps. Yes.
Yes, my lord, we have filed in the lead matters, my lord. They will be, will be clubbed in the respective matters, my lord. Will be clubbed in the respective matters.
Okay.
116.
Hello, Rich.
My lords, the primary objection, my lord, in the writ petition, against the writ petition, or we have received the counter affidavit, is that they're saying that we are not an empaneled, we are not empaneled. So the claim of us being the empaneled is misconceived, and we have misled this honorable court, and got the interim stay, my lord. So, my lord, that statement.
I-24.
So that statement is contrary to their own recruitment rules, my lord. So, my lord.
Then you file rejoinder?
Yes, my lord. That's what I'm praying. The rejoinder is ready, my lord. I can file it tomorrow.
They were saying,
yes.
You're not empaneled, so your claim cannot be sustained.
Yes, that's so.
Regarding that lowering the eligibility.
Yes, so that is only contention, then the primary contention and the strong.
We'll finish
yes,
it off,
yes, my lord. So 19.2 is very
today
clear.
We'll have it.
Yes, I've got signed already. The rejoinder is already.
Finally, we'll have Monday.
Monday, very well, my lord. Monday.
Yes, Mr. You've been Learned Counsel for the praise here to file a short rejoinder.
Yes, my lord.
The affidavit filed by the respondents.
Yes.
So, as the matter of some urgency. Is any urgency? No.
Urgency is there because he has stalled the.
Yes, this is the matter on 8th.
On 8th, my lord. Very well.
Interim order to continue till then.
Yeah, much pleasure.
117.
Yes, Lordship, in this matter, I may be allowed to file my rejoinder, but all the respective party they have filed the affidavit in opposition. Only
file. Rejoinder to whom?
I will file all for all the respondents.
This is the second time asking? Or
yes,
first time?
my lord. This is second time.
Yes, Mr. P.T. Sama Prepons allowed for the 2 weeks time file rejoinder to after the respondents. Just thereafter. For hearing.
No, after that.
118.
Much blessed, Lordship.
Yes.
118.
Hey, please, Lordship. Your Lordship, as per the last orders, we have already submitted that the matter is infructuous, Lordship. Since
Since my senior is not here, Lordship, I'm praying for some time.
Where's the other sub-seniors? They're not here?
No, Lordship. No, Lordship. I'm praying this matter can come up on Tuesday, Lordship. Sir will be present on that day.
Nothing remains here. They already retendered for that portion. Where's Mr. Chanda? He's not here.
No, Lordship.
my lord, and petitioners have been seeking time on last few occasions, my lord. Just on instructions or whether.
Mr. Chanda then took time, that was March, then Kiriam, then De Cruz, then Chanda. Now your name? Lama.
Yes, Lordship.
When?
Tuesday. Tuesday, Lordship.
Otherwise, you withdraw it and file a fresh if you give. Yes, you take instructions. Yes, Mr. TCS Lama, Learned Counsel of the petitioner, raised for some accommodation due to the unavailability of his senior. So, in the interest of justice, this matter of 1 week, it is noted that this matter has been repeatedly adjourned. Expected next date, the matter shall not be adjourned any further. Okay.
119.
Section में
My lord.
My lord, I have filed the affidavit today.
Receipt, my lord.
So let it come after 2 weeks, my lord, for hearing.
For hearing, my lord, then. Fix it for
You
hearing.
want to rejoin that?
No, no.
Mr. S. Hassan,
This is a long pending matter, my lord.
joined
One
the
issue.
to the affidavit filed by the respondents. According to this matter for hearing when?
After 2 weeks, my lord.
After 2 weeks.
Hello.
120.
May I please, lordship. So this matter is fixed for affidavit, lordship. If lordship see the last, as per the last order, lordship, the states
File the affidavit, Lordship.
supposed to file the affidavit. Whether that is on record, lordship, because they said they'll be filing after a week.
It's been filed.
Yeah, we are filed there.
Yes. 55. I thought it was when. Yes, sir. You'll file rejoinder?
Rejoinder, lordship. I'll seek instructions and file rejoinder after 2 weeks.
Obtain instructions as to whether rejoinder be necessary. Just after 2 weeks before order is.
Deeply obliged.
May it please your lordship. Lordship, affidavit in opposition has been filed by the respondents, my lord. But so far as respondent number 5 is concerned, my lord, despite receiving notice on 10/9 of 2025, my lord, she has yet to appear, my lord. So I'm just praying an ex parte order may be proceeded against her, my lord.
Now for second wife?
Yes.
Maybe they have not been served properly.
No, we have already served them a copy, my lord. And we have already, no, by way of registered post, my lord.
You filed a served affidavit?
Yes, I've already filed, my lord.
See?
On 6th October 2025.
You know what happened in this post thing? It happened to this court. The matter was remanded back to Cleria,
Lordship.
criminal matter, for being taken. So the records were here.
Lordship.
So the records are transmitted back to be taken up expeditiously by the court, and the records were sent. It remained in the post, and then when the inquiry was done, why the matter was not taken up, because it appears in the whatever. Found the records were not, they hadn't been received by the court. And it was checked, it was it was in the post office, it was just lying there and shown delivered.
Oh, Lordship.
And see, fixed response fee, then from the postmaster they come down to the poor postman.
Yes.
Saying that he didn't go deliver it. And 8 months had passed, can you imagine? So that's why we are very apprehensive of
Yes, yes, ma'am. Understand,
sometimes they don't deliver it to the person.
Yes, ma'am.
It just goes to the post office where in the vicinity area where they stay, and
it's at page 5, my lord.
Yes, let's see of the FF service.
It was delivered on 10/9 of 2025, my lord.
Post Nirman, she's the one who received it.
Yes.
Yes.
There is word transfer.
Mr. You want to post matter for hearing?
Yes, my lord. No, we will be fine.
Learned counsel for the petitioner pays the matter which is for hearing. He further submits that respondent number 5, those served since 24/9/25 has not appeared in this matter. He prays that ex parte order of hearing be passed against that number 5.
Lordship.
So, will not pass it today. This is a matter for hearing.
Lordship.
And in the interest of justice, allowing the respondent number 5 to make the appearance before the set date, next date.
Lordship.
He's a poor widow, whatever, yes.
122.
Hello, my lord.
Yes.
May I please,
The respondents have sought for time to file.
may I please, your lordship, only respondent number 3 has filed, but respondent number 2, your lordship, I need 2 more days to file the reply.
Respondent number 2, we need 2 more days.
No, they are the issuing authority, my lord.
So only 2 days time may be granted, your lordship.
My lord, as I've spoken to the counsel, Mr. Ibrahim, who's actually conducting the matter, he basically informed me their stance will be the same.
We're not going to go by
No, it's the same stance, my lord.
conversation you had outside the court.
No, it will be the same stance as the affidavit.
As per it further, you already filed.
Yes, you
In the course of the day. Within 1 week. It's for the 1 week's time as paid by as per charging behalf for number 2.
Well, the matter can be list for hearing.
MS EB for respondent number 7. Yes, you already filed it, yes. After 1 week. Let's see. In case you want to file the joinder to the other affidavit. Yes.
Order 23.
Thank you.
Please, Lordship. We are waiting affidavits from the respondents, Lordship.
Lordship, just one final opportunity, my lords. It's already been sent to the department. We're awaiting the signatures.
You're 4 and 5.
4 and 5, my
1
lords.
5 is the MECL.
Please, my lords.
You're not filing.
They are the main respondents.
Who's the main state?
The deputy commissioner is.
Yes, MSS Lalu for 1, 2, 3, 6 and 7 submits that the affidavit be filed. The affidavit of these said respondent will file a court of the day. Stop MSI's EMD Leonard Council for respond 4 and 5. Please phones allowed for the 1 week's time to file. Affidavit. 1 week will do. Yes.
Grateful, my lords.
Yes, thereafter.
Published.
And so forth for the orders.
Published.
Yes.
Please, Lordship.
Lordship, we will be filing the affidavit in the course of the day, Lordship. Corresponding 1 to 3, Lordship.
Mr. Suna, you are paying for Mr. Suna? You're not filing? What you filed it?
Since 4 May.
Okay, Mr. Heman, your council 1 to 3 submits the affidavit will be filed in the course of the day. List after when for your rejoinder, if any.
Your Lordship, 2 weeks, sir.
The 2 weeks for rejoinder, if any.
Order 25.
Yes.
My lord, I'm taking some more time for filing our rejoinder.
How many times have you taken?
Twice.
Is it the third time? What is the second time?
I think it's twice.
You don't know? First, second time, yes. Ms. Amara pays for and allowed 2 weeks for the reason to file rejoinder.
My lord, 2 weeks.
Just thereafter.
Order 6.
Please, Lordship. Lordship, it's just a matter of the signature, Lordship. We have sent the affidavit before the authorities at Dura.
Lordship, this is the 6th time, Your Lordship. Yes.
6th time asking?
Yes,
Not
Lordship.
just only last opportunity. What about number 1? Where's
Number 1, Your Lordship, they are not filing the affidavit, Your Lordship.
number 1?
Union, sir.
Dr. N. Mojika.
Lordship.
Yes, sir. Ms. N. Namari. Submit the affidavit be filed within
As
1
Dahar,
week.
Lordship. As Dahar.
Oh, sorry, within 1 week.
Lordship.
Yes, thereafter, yes.
Last opportunity we given, Your
For?
Lordship. Last opportunity we given.
When it comes to your affidavit, what will happen? Any adjournments? If we say last opportunity, okay.
7.
Yes, for the orders. Yeah.
No, we have already filed our affidavit.
You're for number
4 and 5.
Number 4 and 5. Then
1 and 3 is yet.
You're not filed. You already filed. PS number, you're not filing. Yes. When you're filing it?
My lord, we've already filed our affidavit.
Only filed. You already
My
all
lord, we
copies.
filed on the.
You don't file rejoinder?
We will file rejoinder, Lordship.
Mr. Kharkrang, please with 2 weeks time to file rejoinder to the affidavits filed by respondents 3, 4 and 5. Yes. Just thereafter. And so on. For the order.
So this for affidavit, madam.
My lord, promotion matter and covered matter, my lord, this is.
Now instructions have been received.
The instructions haven't come.
They haven't come.
Some more time, 2 weeks time.
The ACR for the ARE period has not been taken into account, my lord.
Which year?
My lord held this from the year 2020 to 2023, my lord.
Will you suppose it
He was on ARE duty, my lord, at the 26th sector of Assam Rifle, my lord.
After a week, 1 week's time. I'll get instructions.
No instructions have been received in these matters.
I'll get it, man. I'll write to them.
Okay, Mr. Dr. Mozika prays for a week's time to obtain the instructions. So, although Mr. B. Kumar has insisted that the case is covered. Yes. In this, like, according to this, a matter after 1 week.
Yes.
Deep, your lordship.
29.
Hearing this case, lordship, so I was supposed to take step, lordship, because I am yet to get the father's name as well as the phone number of the respondent, lordship, of the respondent, because she is the first wife, and the address which I have got from the PPO, lordship, that was the PPO was issued in the year 1991, lordship. So the private
response. See what was that? They returned it saying that there are many people with the same name in that area.
So, but I put her husband's name, that is the deceased, lordship.
So what are you going to do?
I'll take fresh step, lordship, in the same.
You're supposed to do that in the same address.
Same address. And
that won't suffice.
My lord.
See, the notice 1/5
yes,
is answer with a noting to the sender to provide father's name and mobile number, as there are many persons with the same name in the area.
Mobile number and father's name very difficult for me to get.
Because how does postman reach this person then?
Lordship, true, lordship.
Can you serve personal?
Now what I pray, lordship.
No, can you affect personal service?
If some attempt can be made through the office of the respondent, lordship.
Why?
Tripura, lordship.
Yes, Dr. Mozika.
What?
I have to take steps. I don't think they'll be able to do that.
What my
Mr. S.A. Sheikh, the Parishad submits that in spite of his best efforts, they have not been able to
get
obtain
phone number as well as the father's name.
The phone number, the father's name of the respondent number 5. He prays that some consideration be given, and that the respondents, the state response number 1 to 4 assist the petitioner in ascertaining the correct address and residence of the respondent 5 stop, to enable service of notice, not stop, to enable the notice stop. Dr. Mozika prays that we allowed to obtain instructions from.
Because the unit is located now in West Bengal, for us to go and.
Oh, then it will be difficult because in Tripura, they will. Tripura for now, so West Bengal, how will they obtain? Cancel also. Cancel the whole order. The Sheikh submits that, by the best efforts, have been able to obtain the father's name or the mobile number respondent of 5. He prays without further 2 weeks' time to take fresh steps, same address.
I'll take fresh step, lordship, because getting the father's name and the phone number very difficult for me to.
Fresh steps. You can't get someone who knows to serve personally.
No, my lord, this is because
it's a second visit, man. It's a second visit, Tripura.
Yes.
So I'll take fresh step, lordship.
To Tripura and do shadow home to work. Yes. Yes, that take fresh steps, 2 weeks. These matters then will just.
And my lord, another prayer. They have filed the counter affidavit, lordship. I would like to file the rejoinder, lordship.
To the affidavit filed by the respondent 124, Mr. S.A. Sheikh also prays and is allowed 2 weeks time to file the rejoinder. This is thereafter. And so for the orders. Yes.
130.
Lordship, in this matter I may be allowed to file a rejoinder because they have filed recently the affidavit. they are denying that regularization.
It's a pension matter.
Pension matter, regularization as well.
So it's been regularized. Now they are saying that regularization.
Lordship, the issue here is regularization post-retirement.
Have been regularized post-retirement.
Have been regularized. Now they are saying that regularization have not been approved.
It's against the, it's contrary to the rules and regulations, Lordship.
What about rejoinder?
I'll file a rejoinder, my lord.
What about if we can't hear you. Yes, Mr. P.T. Sama prays that we have to file a rejoinder to the affidavit filed by the respondents number 3. MSB Pasa, however, prayed for further time to obtain or to file affidavit. Prayers aloud. Just after 2 weeks. 2 weeks.
131.
Yes.
This matter state respondent actually they have been asking time and again that this is the third time they have saying that they have received the report.
Earlier, the
Till
time
now
was
they are saying
asked
they have not
only
filed.
for getting the inquiry report, Lordship. Now, on the last date, my Lord has allowed me to file the counter affidavit, Lordship.
We give advance copy.
They have not given me the copy of the report also.
On the last date only, my Lord has allowed me to file the counter affidavit. The earlier time, the matter was fixed for production of the inquiry report, Lordship.
What's the inquiry say?
The inquiry they have not given to me, they supplied to me till now.
It goes against him.
Yes, Lordship. I'll file.
They have not supplied their.
How long?
Inquiry report is not 2-3 days.
Let them supply
2 weeks,
to the.
2 weeks.
You've seen a copy of inquiry report. Have you seen it?
I have not seen because they are not supplying the copy. I have asked. They said they will file it in the court.
Mr. S.C. Sheikh raised funds allowed further 2 weeks time to file the counter affidavit along with the 2 weeks inquiry report. Yes. This thereafter is for further orders.
I also filed actually the miss case, but it's not listed.
134.
Take that up registry.
Much blessed, Lordship.
May please, Your Lordship. Lordship, this is a fresh matter.
Yes.
Lordship, this matter pertains to promotion. And I pray for 2 weeks' time to file an affidavit, Your Lordship.
Yes, that's great. Further 2 weeks time allowed for affidavit. Yes.
135.
And this is also for affidavit, my lord. We have received instructions, my lord. 2 weeks time we will be able to file.
What's this matter?
This is a contract matter.
Contract matter, Lordship. Reply was to be filed in this case.
When was this matter filed?
This matter was filed on the first hearing was on 27th of March, Your Lordship.
This,
and as regard respondent number 2, my instruction is that they have been served, Your Lordship. I will be filing affidavit by the next date.
What about 5? You file affidavit?
We are yet to receive instructions.
From whom?
From the registrar.
What's your name?
Who's number 2?
Name. Name, I can't, it's, your audio is not clear. Yes. What's his name?
It says Mr. Amit Kumar.
No, Mr. Amit Kumar is RP General.
Okay.
Yes, your name. G Das. Is it G Das? Where are you based in Guwahati? Where is he based? This is
He's appearing for Jim, my lord.
He may type it out in the chat box, Lordship.
This is sometimes they have very bad connectivity. So, oh yes, she's aiming for Jim. Yes, Mr. G Das was respondent number 10 is an appearance today on B.
Respondent number 2.
G Das appearance will be out on number 2. Such notice complete all respondents. Stop. Next para Dr. N. Mozika, Learned Counsel for respondents number 1, 3 and 4.
1, 3 and 4.
1, 3 and 4.
And Mr. for respondent number 5. How much time you require?
2 weeks.
1 week's time is enough, Dr. Mozika?
2 weeks, my lord. Is quite
Yes.
lengthy matter. 2 weeks time.
2 weeks time for
2 weeks time to file rejoinder also.
It's expected that the next date the affidavit will be on board. So, you want
The date may be given between 6 to 10 July, Lordship.
Yes, want to request, what is your name? Sorry?
Abhay Endas, A.
So
Endas.
on the request of Mr. A. Das, that the matter appear in the 2nd July to allow for filing rejoinders in the meanwhile too. Yes, you file your affidavits.
We file.
136.
Lordship, I'm praying for further time to file affidavit on behalf of the state respondents 1 to 3. This is my second such prayer.
M. Surang, working for whom?
Please, Your Lordship. Your Lordship, I'm appearing on behalf of respondent number 4 and number 6, Your Lordship. Your Lordship, I'm praying for 1 week time.
Yeah, D. Timung. For respondent number 6. What's the matter about?
This is regarding to land acquisition.
Where? Penusla.
Penusla bypass.
Penusla, Your Lordship.
Penusla.
When are you going to file it?
Your Lordship, we just need one week time, Your Lordship.
You have both for 4 to 6?
Yes.
Yes, Your Lordship.
And you're for 5. You're for 5. You're for number 5. Yes, Mr. ASD for 1 to 3. MS M. Surang for 4 and 6 and D. Timung for 5. Pray for allowed further 2 weeks time for affidavit. Yes, is that after?
137.
Please, Your Lordship. We shall pray for 2 weeks time to file affidavit on behalf of Miss Z.E. Nonkindri.
On behalf of?
Miss Z.E. Nonkindri.
Filing on behalf of the state or on Z.E. Nonkindri? She's a party in the case.
No, Your Lordship.
And then?
She's a conducting counsel, Your Lordship.
Yes. No private respondents?
No, Your Lordship.
Yes, aspirate for the 2 weeks time allowed affidavit this thereafter and so on.
Obliged, Your Lordship.
138.
Why not here the service report is awaited? We have taken a step to the private respondent, Lordship. Against his Lordship.
Yes. How much time? 2 weeks?
2 weeks, Your Lordship.
2 weeks for the time.
For 1, 2, and 3, Your Lordship. For Your Lordship.
Ms. MS Ailingwa, Learned Counsel for 1 to 3, and MS Impasa for 4. Pray for allowed for the 2 weeks time to obtain instructions and to file affidavit stuff. It is noted that the service is yet to be complete. Respondent 5 and 6. These are 2 weeks for affidavits and for appearance of 5 and 6.
Much obliged, Lordship.
Yes.
Second call, supplementary list 3. Supplementary list 3.
This is a matter pertaining to establishment of non-tribal gate ballot by the under the authority of the district council. This matter is well settled, my lord, that the district council has.
Yes, they have some objections to this courting of this matter. Let's go for another bench.
My lord, kindly see.
Why? What was the objection?
Kindly see the objection on page 40, my lord.
Page 40?
Page 40 is the previous order on which we are relying in this matter, my lord.
Yes.
Now, your lordship as senior counsel appeared for the petitioner, my lord, and the petitioner lodged this case at that point of time. That matter, my lord. But now, only because your lordship appeared as a counsel, the matter may be connected, my lord. And only because you are relying on this decision, 2016, my lord. So that cannot be, in my humble submission, ground for recusal, my lord. Your lordship appeared in so many matters. As long as the party is not there, my lord.
Yes, Mr. Shulai. What is the problem?
I'm just I'm bringing to your lordship notice is lordship because in the earlier writ petition by the same petitioner, lordship was pleased to recuse the matter. Just I'm informing that only, your lordship. Otherwise, I have no reservation, your lordship.
But only because
this is matter.
Otherwise, I have no reservation, your lordship.
Hearing. Supplementary 7.
Apply, Your Lordship.
Supplementary 7.
Except one.
7. This.
Please, Your Lordship. May I just first take Your Lordship, just to refresh Lordship's memory?
5 minutes, yes.
My Lord.
Before we start,
Let's keep this on top.
The fellow who came late.
Lordship.
So do we have proceeded somewhere with that regarding that you don't need another extra seat? Only now with the aspect of whether with the same need score the person can be accommodated. Right,
my lord.
Yes.
That was my alternative prayer, my lord. But may I
What
just
happened to
take-
NEET exams now?
My lord, there are directives that NEET score is valid only for 1 year, my lord, and there are Supreme Court decisions that there cannot be any telescoping, my lord.
But now they can't sit for NEET also. What will happen?
You can sit, my lord.
No, the exams have the papers leaked.
This might be a recurrence next year.
Yes, so what
We don't
happens
know.
next year again?
Might as well take one student.
Might as well get one student from the old NEET.
May I just give you lordships a brief overview, my lord. Please take page 66. This is the judgment passed in the earlier writ petition, my lord. 17th of December 2025 was the last judgment.
Page 16.
Page 66. 66. Then the relevant portion is page 70.
Yes.
My lord. Please have para 7 minutes. I'll just read these paragraphs.
Yes.
Para 7. As such, in view of these instructions, this court cannot direct for creation of supernumerary seat inasmuch as the lapses were directly attributable to the petitioner himself. However, looking into the totality of the circumstances wherein an aspiring candidate has been deprived of pursuing a PG course for which he had legitimately qualified, his case merits some redressal. Accordingly, it is directed that the respondent number 3 on a fresh representation being filed by the writ petitioner shall take the same into consideration and take appropriate steps to forward the said grievances to the National Commission for Homeopathy to explore the possibility of creation of a supernumerary post in favor of the petitioner. This direction is being passed in view of the fact that there is no redressal mechanism when such situation arises. Now, all throughout, no affidavit was filed by the respondents in this particular proceeding, but the representatives of the institute were present. So it was expected they would apprise the court of the facts correctly. For some reason, the fact that the intake capacity, the original sanctioned intake capacity was X, was not informed to the court. Now, we were made to believe that the original sanctioned strength has already been filled up and therefore the need for creation of a supernumerary post. That is always in addition to the intake capacity. Now, pursuant to your lordship's judgment, we filed a representation highlighting everything that was relevant apart from the fact, including the fact that I'm from a marginalized community, my socio-economic background, etc. And then, my lord, the order that was passed is at page 80, which was passed on the 8th of January 2026. So my lords had indicated to them that there is no redressal mechanism, 80. Okay. That in view of the fact that there is no redressal mechanism, his case should be considered favorably. Now please see 8 Jan 2026, the relevant part, my lord. With reference to the subject cited above, this is to inform you that the Homeopathic Education Board, National Commission for Homeopathy, had examined the matter with regard to creation of a supernumerary seat. This is what they're examining. In favor of the petitioner for granting admission to PG Homeopathy course for the academic year 25-26 in light of admission guidelines issued by so-and-so. As the admission process for the academic year 25-26 is already over on 22/12/2025, therefore, the above representation submitted by the petitioner cannot be considered at this stage. Now, this order is passed on the 8th of January 2026. Surprisingly, 5 days later, the other order comes to be passed on 13th of January 26, which is at page, the next page, my lord, 81. Now, please see this. The subject is this: extension of the cutoff date, last date for admission in the undergraduate and postgraduate courses for homeopathy for the academic year 25-26. Please see the second paragraph. Accordingly, the concerned authorities are requested to take necessary action in time as per the rules and regulations, and they extend the cutoff date to 23rd January 2026. So this I'm submitting, my lords, was definitely within their contemplation 5 days earlier. It is the same department, the same authorities. They were well aware. Now, immediately thereafter, my lords, very promptly I filed a representation on the 15th of January. But till date, that was not considered. Now, in response to the writ petition, an affidavit has been filed. It's a short affidavit by their own, by the contents of this affidavit, and my lords, the relevant part, they don't address it on a parawise basis, but what is relevant is at page 8, one of the annexures, my lord. This is a letter dated 13th of June 25, issued by the National Commission for Homeopathy.
13th of June, right?
13th of June, my lord.
Yes.
My lords, please see the line which is 6th line from the bottom of the first paragraph. It begins with the Medical Assessment and Rating Board.
Medical
Assessment, and the 6th line from the top. The Medical Assessment and Rating Board, MERBH.
Where reading from? 6th line from the
first paragraph, 6th line from the top.
1, 2, 3, 4, 5. Yes.
Yes. The Medical Assessment and Rating Board, MERBH, has conducted inspection on 22/5/25 and 23/5/25. MARB has examined the profile of the college as to whether the college fulfills the minimum essential standards 2024 as per the prevailing regulations under clause 2628 of the NCH Act 2020. On careful examination of the report, the Medical Assessment and Rating Board observed the following shortfalls. So they highlight certain shortfalls, and then please see the paragraph at the bottom. An affidavit of declaration is submitted by the director in charge of NIA, considering the assurance provided in the affidavit by the authorized signatory and competent authority, where it has been mentioned that the shortage of faculty at NIA will be filled up in the current financial year. MARB has decided to issue conditional permission to the NIA for continuing UG course with intake capacity of 63, including EWS seats, and this is what we are concerned with, and for postgraduate MD with intake capacity of 8 seats. In 4 subjects, namely 2 seats in organon medicine, 2 seats in repertory, 2 seats of homeopathic materia medica, and 2 seats in practice of medicine for the academic year 25-26. Now, well, it's the sanctioned intake capacity for PG was 8 seats, and for UG was 63. While advertising for that particular year in the prospectus, they advertise all 63 for UG, but as far as PG is concerned, they advertise only 2 seats. And the previous round, we are led to believe that the original intake capacity has been filled, and so therefore there is a need for creation of a supernumerary post, and which can only be accorded permission, my lords, by the center. That wasn't the case here. Now it stands revealed at a very late stage that they already had a sanctioned strength of 8 seats. So where is the question of supernumerary seat? So that previous direction itself was on a wrong instruction issued. So, my lord, most importantly, Lordship's direction was very clear.
Now, how will we resolve it then? Apart from taking them to task.
So, considering we are in the month of June now, and this affidavit is filed very late, and this instruction, now this fact stands revealed, there has been some impropriety on the part of the respondents. This should have been revealed right from the start. Had this been revealed, I'm sure, my lords, the outcome would have been very different. I'm very confident. That being the case, my lords, I don't mind going into the course at this point, but this I will only suffer. I will suffer because several months have gone by. I don't think I'll be able to catch up.
25, the session commenced from?
December 20, last week of December, if I'm not wrong. But the admission, if your lordship sees, the last date of cutoff was 22nd of January 2026. So there are a lot of students perhaps who came in that time. But still, even if I discount that, 5 months have gone by. So there's a lot of catching up for me to do, which may not be fair on my part. So I'm only praying for molding of relief, my lord. My learned senior has pointed out there is some concept of telescoping. I'm not aware. I'll have to just examine. But lordship, there was a judgment that I had referred to. I had supplied it on the last date, my lord. This is a case of Shireen Dakhar versus State of Meghalaya, if my lords have that. My lords will kindly take the last page, page 10.
Yes.
In this case, the background is this. The petitioner had been allotted a seat under the reciprocal arrangement between the states, between the state of Meghalaya and the state of Assam. She secured the seat, she started her course. Subsequently, some other student who had fared better than her in the NEET score, he came to learn about this allocation and he challenged it. Upon his challenge, not before the court, but upon his challenge before the concerned department, the department recalled her admission. So that is why we were before this court. Lordship had molded the relief, noticing that that original post was never advertised. There was no proper advertisement. So Lordship allowed the petitioner to retain the seat, but by molding the relief, allowed this other respondent to secure the seat for the next academic year. Well, we'll see para 11.
Yes.
In the present case, the private respondent being more meritorious, in the considered view of the court, deserves the same concession, that is to the molding of relief and to direct for admission to be granted in the next academic year in the MDS PG course with the same NEET score. It is further noted that though the judgment refers to the admission in the MBBS course, the same principle would apply to the incident case which involves admission to the postgraduate medical course. This judgment was the case of
Krishna Shraddha.
My lords.
Have you given
the last date of
copy of the
Krishna
judgment?
Shraddha ka judgment? That supplied on a previous occasion. I'll supply this copy again, right? Although this related to the MBBS seats, the same principle has been made applicable. My lords will see the last page, page 478. Let's have it.
Yes.
May I just read para 13.1 onwards? That in a case where the candidate student has approached the court at the earliest and without any delay, and that the question is with respect to the admission in medical course, all efforts should be made by the court concerned to dispose of the proceedings by giving priority and at the earliest. Under exceptional circumstances, the court finds that there is no fault attributable to the candidate, and the candidate has pursued his or her legal rights expeditiously without any delay, and there is fault only on the part of the authorities, and there is apparent breach of rules and regulations as well as related principles in the process of grant of admission, which would violate the right of equality and equal treatment to the competing candidates, and the time schedule prescribed is over. Now, my lords, here the time schedule was stagnant. In our case, the time schedule has already been extended up to the 22nd of Jan. To do complete justice, the court, under exceptional circumstances, in the rarest of rare cases, direct the admission in the same year by directing to increase the seats. However, it should not be more than 1 or 2 seats, and such admission can be ordered within reasonable time. That's the case where the intake capacity was stagnant again. Therefore, there was a need to increase the number of seats. That is within 30th of September, that is cut-off date, and under no circumstances the court shall order any admission in the same year beyond 30th October. However, it is observed that such relief can be granted only in exceptional circumstances and the rarest of rare cases. In case of such eventuality, the court may also pass an order cancelling the admission given to the candidate who is at the bottom of the merit list of the category, who, if the admission would have been given to a more meritorious candidate who has been denied admission illegally, would not have got the admission if the court deems it fit and proper, however, after giving opportunity of hearing. In case the court is of the opinion that no relief of admission can be granted to such candidate in the very academic year, and wherever it finds that the action of the authorities has been arbitrary and in breach of the rules and regulations or in the prospectus affecting the rights of the students, and that a candidate is found to be meritorious, and such candidate student has approached the court at the earliest and without any delay, the court can mold the relief and direct the admission to be granted to such candidate in the next academic year by issuing appropriate directions, by directing to increase the number of seats as may be considered appropriate in the case, and in case of such an eventuality, and if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case the court may direct to reduce the number of seats in the management quota of that year, meaning thereby that the students who had been denied admission illegally to be accommodated in the next academic year are out of the seats allotted in the management quota. Now, this proceeds on the premise that there has been some fault attributable to the college authorities, and there is no fault attributable at all to the candidate. But my lords had noticed that the petitioner is from a very difficult background. He's from a marginalized community, and what was his fault really? He was late by about 2 or 3 minutes, not exceeding 10, 15, half an hour. So therefore, lordships had very clearly noted that his case merits some sort of redressal. So therefore, I would only pray with folded hands, my lords. Please consider his case. I think he's meritorious. We're not asking for much. We don't want to disturb the present line of admissions. We're only asking for some admission in the next year. I think his case can be suitably considered and some sort of molding can be ordered for the next academic year, my lord.
Well, I'm placing some. But my lord, before coming to the reasons, I'll just point out one thing, my lord, from the representative.
Yes.
Lordship seen the order was passed by Lordship on 17/12/25, my lord. Page 66 of that question. Asking them to submit a representation and inviting us to dispose of the representation, my lord. We disposed of the representation, page 80, Lordship will see, on 8th of January 26.
Yes.
Now extension comes on 13th of January, my lord. So there can only be some presumption that it was within our knowledge, but it cannot be established, my lord. The 8th January and 30th had been in the case of disposal of representation after 13th January, matter would have been different, my lord. But this representation was disposed on 8th January, extension comes on 13th January.
Was it disposed of on
8th of January, page 80, Lords will see on the representation. Extension comes on 13th of January, my lord. However, though we have not filed an affidavit, with the purport of this extension can only be the vacant seats. If there are any vacant seats, you call for fresh rounds of counselling. Here is a case, my lord, the seat already stands filled up on 22nd December itself, my lord.
You didn't say that here.
But that can
how can we read that into this?
But that can, my lord, counselling happens stage-wise, my lord. First round of counselling, second round of counselling. The admissions who have already been granted admission, my lord. This extension cannot mean that they will be thrown out, my lord.
You mean only for people who have taken admission?
Only the seats which remain vacant, my lord. The extension of counselling can only for that purpose.
Vacant people have not applied at all.
No, my lord. On the date of counselling, if the candidates don't report, my lord, seats remain vacant, or a particular quota seats remain vacant, my lord. It cannot be that, my lord.
Where we made a statement affidavit.
But we have not said that, my lord. But the whole purpose of this extension is only to that extent, my lord. But this extension cannot mean that a candidate who has already taken admission, my lord, who has already been granted admission, can be now undone.
But it says like that. Extend your cutoff date. As the admission process is already, go to your previous letter, page 80, to inform you that so and so and so, in light of the admission guidelines issued by the admission process for the academic year is already over on 22/12/25. Simple as that. The
But what I understand, my lord, the admission,
is not the counselling.
my lord, the admission happens in various rounds, my lord. First round counselling, top meritorious students called, my lord. Now here what happens, my lord, many meritorious they get admission in multiple colleges, my lord.
How we get that? We understand that.
So my lord, they have the choice to choose one particular according to their choice, my lord. So what happens, they don't report for counselling, my lord, those seats remain vacant. And that is why second round is called, third round is called, my lord.
But where does it say that in the letter? According concern, sorry, okay, so leaving this aside, okay.
Even we overlook this aspect, my lord.
Leaving aside, how will you address the case of the petitioner? Because the other fact that stares us in the face is that you allowed 8 PG seats, for which you advertised.
Homeopathic council sanctioned 8 seats, my lord. The seats are sanctioned by the medical council or homeopathic council, my lord. Not we wrote to them, my lord. We informed them we don't have the faculty, we don't have the infrastructure, so we can only, because we don't have teachers, my lord. These are highly practical, my lord, homeopathy and Ayurveda courses. So on the basis of the number of faculty available with us, we advertised one post, my lord.
Where is the state in the affidavit?
We advertised one post, my lord. That is admitted position. There was only one post, my lord, for homeopathy, for which he applied.
What is submitting today is totally over and above the affidavit.
Or because in the previous round we didn't file affidavit. But otherwise also, my lord,
even the second affidavit, then you could address this.
Second affidavit, we addressed that, my lord.
You made a statement?
Yes, my lord.
What's the difference between 2 or 3 students, PG students? Now we have 2 PG students.
Well, sanction strength is 2. We are allowed to take 2 admissions, my lord. But because NIA doesn't have faculty,
sanction strength is 8.
In 4 subjects, my lord. Here is the case for admission to homeopathy, my lord. So homeopathy, we have 2 sanction posts, my lord.
Already filled up.
We advertised only for 1 post because we don't have infrastructure and faculty.
You advertised only for?
We asked for admission to only 1 post, my lord.
That's PG in homeopathy.
My lord.
And both the posts are filled up now.
Only 1 post, my lord.
Okay.
Sanctioned is 2.
And the other?
But we wanted intake of only 1, my lord.
Very hard to digest that. One sanction is there, sanction.
May I just also point out, this affidavit is filed by the National Commission for Homeopathy. If there was any further communication between the parties saying that I do not have the required faculty, they would have brought this out in this affidavit. Nothing has been brought. There's no whisper about it.
Well, because Homeopathy Council affidavit was filed, so we have not filed affidavit on behalf of NIA, but if necessary, we can file that also. But well, more importantly, where we stand now, the Supreme Court has very clearly said that in medical admission, there cannot be midterm election, number 1, my lord, and number 2, no telescoping, my lord. Now, what telescoping, the Supreme Court, I'll just place these 3 decisions, my lord.
Is the judgment?
Yes, my lord. 2002, volume 7, my lord, the first decision.
Para?
Para 23.
Para?
Para, last para, the conclusion.
23?
Yes, my lord. There is, however, a necessity for specifically providing the time schedule for the purpose and fixing the period during which admissions can take place, making clear that no admission can be granted after the scheduled date, which essentially should be the date of commencement of the course. In conclusion, there is no scope for admitting students midstream, as that would be against the very spirit of the statute governing medical education. Even if seats are unfilled, that cannot be a ground for making mid-session admission. There cannot be telescoping of unfilled seats of 1 year with permitted seats of the subsequent year. MCI shall ensure that examining bodies fix a time schedule specifying the duration of this course, the date of the commencement. So, those are not relevant. Basically, the direction is there cannot be any telescoping for next year, my lord. But the next, the subsequent decision of 2014, volume 10, SCC 521, para 25. Para 25. Chandigarh.
Yes.
Para 25. The recent decision of this court in Anis D. Lavande was relied upon by the London Council for the Appellate. This court has called out 2 main principles to be kept in mind in such cases. In para 30, the said principle have been let down, and in para 35, this court
Where did it from?
Para 25.
Yes, in para 30 itself. Okay.
The recent decision of this court in Anis D. Lavande was relied upon by the London Council for the Appellate. When this court has called out 2 main principles to be kept in mind in such cases, in para 30, the said principles have been let down, and in para 35, this court has reiterated as to why it will not be proper to issue license to adjust the students of 1 academic year in any subsequent academic year, by pointing out that such a course would affect the other meritorious candidate who would be aspiring to get admission in the subsequent year. It was stated that for bringing equity to some in presenti, this court cannot afford to do injustice to others in future. This is quoted, my lord, Anish D. Lavande. The next submission relates to the issue whether the students who cannot be adjusted in the seats of All India quota that have been transferred to the state quota in this year can be adjusted next year. During the course of hearing, though there was some debate with regard to giving of admission to such students in the academic year so and so, Mr. Amit Kumar, Learned Counsel for the Medical Council of India, had seriously opposed the same, and thereafter he cited the authorities we have referred to herein before. We are bound by the said precedent in certain individual cases where there is defective counselling and merit is become a casualty. This court is directed for adjustment in the next academic session, but in the case in hand, it is not exactly so. Though we are at pains, yet we must express that it will not be appropriate to issue directions to adjust them in the respect of the subsequent academic year. For taking recourse to the same would affect the other meritorious candidate who would be aspirant to get admission next year. For doing equity to some in present, we cannot afford to do injustice to others in future. Therefore, the submission stands repelled.
Next one.
The third decision, para 29, 19, 20, and 21. Para 19 says, the court at first blush may be persuaded.
Para 19, 20 and
19, 20, 21. This court at the first blush may be persuaded to take a sympathetic view in these kinds of matters, as the career of a young girl who is on the verge of entering higher studies could be jeopardized. However, the same would not be sufficient by itself to give direction to the NTA, which is a great responsibility of smooth and peaceful conduct of exams for more than while maintaining discipline and also ensuring that the same is uniformly enforced across the country. There may be hundreds of students who may have reached the examination center late, and an exception cannot be created in favor of the applicant. Moreover, there are only 3-4 days of the examination which are left now, and in such circumstances, the NTA cannot be expected to now create a separate schedule. Next parameter, purity is important. So basically, this is on the line that the candidate reports late, my lord, and the judgment relied on by my friend, my lord, are all where at least there is no fault on the part of the petitioner, my lord, and there is some fault on the part of the authority or the department. Now here is the established case, my lord. It is the admitted position that he reported late.
How many minutes?
Well, minutes will be immaterial, my lord. If the bus starts, my lord, now. If we miss the bus, my lord, then we missed the bus.
There's another case passed by the coordinate bench whereby they didn't go for counselling also. He filed a case.
But there was no fault on the part of the petitioner, my lord.
Where?
In the other case, my lord.
Not this case, I mean the other case from this court only, regarding school. He didn't go inside to receive messages for counselling and turn around and went and filed a writ and has succeeded.
The shortage of attendance, my lord. Shortage of attendance.
Into KG or nursery, whatever. Now after receive messages, didn't go for counselling. Then went later on, and then when being refused, and that because seat became someone else, filed a writ and got pulled to leave.
Well, there may be possible to, or which course I don't know, because in the medical seats, mid-stream admission.
No, I'm just saying. Yes.
So that will the matter. He is at liberty, my lord, when the next NEET examination happens. If he is meritorious, my lord, he again come out with flying colours and he'll get admission.
Yes. Very quickly, there are 3 judgments that have been referred to by my learned senior. The first judgment of Medical Council of India 2002. First of all, it's from 2002. There's a lot of water which has flown under the bridge. The second judgment, this is important, this is Jasmine Kaur, which speaks of telescoping, not permitted. Jasmine Kaur was one of the divergent views taken which resulted in the reference in the Shraddha Arya's case. Let's please see the judgment of 2014, volume 10 SCC 521. This was a divergent view with already existing judgments, and therefore there was a reference made to a larger bench of the Honorable Supreme Court, which resulted in the case of Shraddha Arya that I am referring to. Now in Jasmine Court, they say telescoping from one academic year to another academic year is not permissible. And with regard to unfilled seats, Shraddha Arya talks about a different situation altogether. They disagree with Jasmine. So therefore Jasmine is no longer good law. The larger bench in Shraddha Arya takes a divergent view and they set down the principles. This is the Chandigarh administration.
Chandigarh administration versus
Jasmine Court. Now please see Shraddha, the Krishna Shraddha judgment that I am referring to. Yes, well, no, it's Krishna Shraddha. This is 2020 17 SC 465, the one that I referred to today. The first judgment that I placed.
Okay. Yes.
Just take out
the names are similar with the other case. Sadhana Yadav. Yes.
Krishna Shraddha, sorry.
Yes, got it.
My lord. Now here
they refer to where they refer Jasmine Court.
Yes, please see page 469 of the judgment. In fact, on the very first page, my lord will see. Just below the head note, in Jasmine Court 2014 10 SCC 521. And if your lordships look at 469, they talk about the reference. Page 469, para 6. As observed here and above, the contrary view is taken subsequently in Jasmine Kaur.
Yes.
They are referring to that same judgment. Please see the footnote. State of Chandigarh versus Jasmine Kaur 2014 10 SCC 521.
So no longer good law.
My lord. Because they're taking the exact different point here. If your lordships look at para 13.3 and the last page.
Yes.
So they say it's permissible. Of course, I'll be fair, my lords. They do say here the fault should lie with the university. Now, my lords, we can't have a straight jacket set of facts. All facts cannot be identical. My lords, you also remember the first round of litigation I had referred to the judgment of Shreya Kumari Tirke, where the courts have held special consideration should be given to people from marginalized communities. Well, that has not been discussed here. Look, I have that judgment. Let's just have a look at this judgment. I apologize, this is my judgment. I seem to have misplaced the previous set for your lordship. This I had referred to in the previous round of litigation. I'll supply a fresh set. Here, my lords, they had discussed everything. Redressal mechanism, disproportionate punishment, and they had held that in such sort of situations, especially considering a candidate who's from a marginalized community, court should give some sort of leniency. And there was a direction for creation of a supernumerary post. So as there can't be identical facts in all cases, and once we look at what is the nature of my fault, I was a few minutes late. Not a case where I am not meritorious. I was meritorious. And presently, I'm not asking to be accommodated in the same particular year, but in the next year, next academic year. Now, the only judgment on the issue of telescoping has already been set aside. A contrary view has been taken and the principles have been set down by the larger bench of the Honorable Supreme Court, that it is permissible. So ultimately, it's the conscience of the court.
No need a need score. How do you reconcile that?
My lord?
How do you reconcile a need score thing? Because there's no judgment to say that they can take.
No, my lords, this judgment of Krishna Shraddha, it again says he can be accommodated in the next academic year. Not that he has to sit again.
Dehorse the score.
Dehorse the score. The directions coming from the court ultimately. So I will only ask for special consideration, keeping in mind the extraordinary set of facts here in our case. They did not inform the court that there was an intake capacity of 8 seats. Had they been informed, perhaps we would have gone in for a full-fledged hearing and lordships would return to a different finding. Now, we travelled a long way on the issue of creation of supernumerary posts, only to find that they already had the intake strength.
But there's one deficiency your part, you not put this in affidavit.
Nothing. And my lords, will see in the affidavit, what do they say? On being authorized, I am competent to swear this affidavit on behalf of all the respondents, including the institute. And the council is also the same. So now they can't say that the institute will file a separate affidavit at this stage, at a ripe stage of hearing.
My lord, they cannot take advantage only of the situation, and I placed, my lord, representation was disposed to 8th January, extension was granted on 13th January, my lord. So what inference can be, adverse inference can be drawn from that, my lord? Had it been otherwise, my lord, some adverse inference could have been drawn. That's first submission, my lord.
Yeah.
Second submission, all the judgments, my lord, say the petitioner is not at fault at all. There's a clear admitted position, my lord, that he was late.
So because of that,
and the NEET score is valid for 1 year, my lord. I place the decision, my lord.
So without entering a NEET score, you can't take admission? Cannot. Valid NEET score, you mean?
Yes.
So, where does it say that?
In Shireen Dakhar, on the basis of the same NEET score, the order were passed. State did not challenge it. State, in fact, accepted. The learned AG had appeared in the matter. He also referred to Shraddha's judgment, and he said it is permissible. And incidentally, my lord, he was representing the Medical Council of India.
Who's this person whose name? This is a person, this is a petitioner. This one?
But this is some other candidate.
No, this is somebody else's scorecard.
But the standard scorecard, it says that it is valid only for that particular admission. Had he reported in time, my lord, and then he was deprived admission, he had a case, my lord.
So fault not entirely attributable to you?
No fault attributable to us.
No, I'm not even saying that, my lord. I'm saying, but my lords, what is the nature of my fault? The punishment is disproportionate, which is why, my lords, what I will do, I will make a compilation of those same judgments, including that Shreya Tirke's judgment. This is a very important judgment from last year itself. There, several principles have been laid down, several parameters have been laid down. Lordships will just examine that. I'm only asking for special consideration, leniency.
I kind of see the situation, my lord. We have to throw that out to the candidate who got admission, who's not even a party in this case, my lord.
No, my lords, I'm asking for molding of the relief.
What about the prospective candidates? That's what Supreme Court has said.
No, that is from an old judgment.
Do justice in presenting, my lord. You cannot do injustice to future prospective candidates, my lord.
Yes, but then again from an old judgment, from Jasmine. Jasmine is an older judgment, my lord.
Okay.
But I'll just submit a short note on this, including those judgments of Shreya Tirke, etc., which I had relied on. I'll have it tomorrow or day after, as per your lordship's convenience.
Yes, matters heard. Mr. S. N. Page will have to file a small
note, my lord, with including those judgments.
Yes, including judgments cited today.
Also,
Yes, similar prayer made by Dr. M. Mojikam, just a matter day after lordship. Yes, for filing of the notice.
Obliged, my lord. Highly obliged.
139.
Please, your lordship.
They were supposed to file a
The objection, lordship. We'll be filing it in the course of the day.
What objection is this? Where's the application?
Objection to
Have
the
you filed an application for adjournment to file it? Who's your leading counsel?
A.S. Pandey, lordship.
Where's Mr. S. Pandey?
He's on Lex, your lordship.
This has been going on.
File it.
Yes, we'll be filing it in the course.
You don't make all submission. You make an application.
Yes, sir.
Have you practiced the lower courts? You must have. So if you ask for adjournment, what do you do?
To file an application.
Yes, this is election petition. It's like a trial court. You have to file an application. It's not under 226. Okay.
May it be fixed next week, lordship.
Yes. You file an application, we'll pass orders. Okay. Yes. You can sign it yourself. No issue.
140.
No, please, your lordship. Lordship, on the last occasion, lordship has already heard this matter and was pleased to direct the respondent, my lord,
To seek some
clarification, my lord.
Clarification.
That regarding?
This is an Nokmashi matter.
This is a Nokmashi matter, my lord. This is in regard to that same map, my lord.
Okay. Yes.
Praying for some time, my lord, since the things are settled now in District Council of India.
They settled down now?
Yes, yes.
Mr. SD prays that without further time to obtain the clarification as ordered by this court by the order dated
13/3/2026, my lord.
13/3/2026. The prayer is allowed list of 2 weeks.
3 weeks. I'll do it positively.
This is the letter. We expected on the next day specific instructions will be received.
Highly obliged, my lord.
141.
As per the last order dated, my lord, I have filed the additional affidavit to bring on record that I have been regularized.
Have you got a copy of that MS?
I've served a copy.
Yes.
Now the case of the respondent, yes. One more. One more is there. Seven. Mistake there. Then the annexation. Oh yes, this is correct one. Correct one. In the additional affidavit, my lord, I have twice I have been regularized.
Why you been regularized?
Regularized in the same post. Then only after twice regularization, then the departmental promotion, they have promoted me to the again this one, the sectional assistant. Yes. Purely regularized representation.
Now it was from 1999.
Yes.
Okay, that you are.
So the annexure, I have annex. Well, you do not put annexure also. 1, 2, 3. It's written there also. You are not doing properly.
This is mentioned absorb as work charge section assistant.
Yes.
What does it mean? What do we mean by this letter? How can we absorb as work charge temporarily?
That is this is the official.
And the second one?
Second one again on 27/5/1999. There I have put it. Why different page?
Both are page 7 and 9 is same. It's the same order.
I think my
See, what
they
have
have
you
make a
given here?
mistake actually. Why you make them check it? Actually, in my copy, I think they might have.
How? When affidavit, then the. What is this? See your 9 and the other 2 annexures. Same order, same one twice.
Yes.
Being absorbed twice doesn't mean that you execute the same order twice.
No, actually, Lordship, they have make a mistake.
Who made a mistake?
Actually, my colleagues were filing. Actually, it should have been the 27.
I made a mistake. Why should you blame your colleague?
Not the court, my lord. I apologize, my lord. Actually, it should have been the 27/5/1999.
We don't know about that.
This
Yes,
is the,
Mr. Petitioner submits that due to an advertence, wrong annexure has been annexed to the additional affidavit allowed by this court by the order dated.
by the order dated. This one is there, lordship. We never check. Order dated 11/5/2026.
Yes, sir. We praise that we allowed to replace the same.
As per
the same not objected to by counsel of the respondents. Yes, praise allowed.
We will
correct the replacement should be done within 1 week. Yes.
You never checked. Never checked.
Much oh, you that? Should be careful.
Yes, because much pleasure.
Yes.
I'll put 2.
Lordship, this matter actually where it is.
What you will do? You will ask for time or what? You will ask for time?
My conduct counsel, Mr. Hassan, he's on legs.
Okay, then
yes.
My lord, my conducting counsel, Mr. Hassan, he's on legs before court number 1. So kindly fix this matter after 1 week.
Lordship, I have no objection, my lord.
What review is it?
Actually, only the name was mistake was there. Actually, small.
It's due to the absence of the conducting counsel. We have respondent number
567.
This is a matter for 1 week.
Apply, your lord.
Much pleasure.
143.
This matter may come after some time, my lord. Maybe after 1 week, my lord.
Nokma matter?
Yes.
Not 2 o'clock?
Not 2 o'clock, my lord. After 1 week, my lord.
Yeah, objection. You have any objection? He's asking for 1 week's accommodation.
Let him take 2 weeks, my lord. What is that?
No problem. You're a sitting Nokma?
Yes.
There
no urgency?
Not urgency, actually.
Okay. Are the requests also after 2 weeks? Yes.
Much pleasure, sir.
148.
My lord, some instruction was sought for the last occasion, my lord.
May I please, your lordship? Your lordship, senior counsel is currently engaged in court 1.
So what instruction?
Lordship, I have not authorized.
Not authorized?
Lordship, I seek for some accommodation, your lordship.
Who's the petitioner? Yes. This.
My lord. The benefit of 7th pay commission has been given to the petitioner, my lord. But some in graduate.
Dr. Mozika is not here now. He's gone. He's on leg.
My lord. Then next week, my.
Yes, after 1 week, yes, Dr. Mozika is busy in other court. Yes.
Highly obliged.
My lord.
150.
May I please, your lordship? I have to seek some accommodation in this
Why?
matter. The conducting counsel, our colony, she's on legs too much.
Who?
For the private respondent, our colony.
She's there as Sham come and
For the
advocate
state,
then.
my lords.
For the
What's matter
private
about?
respondent.
My lords, this is for the VC, my lords.
Yes, matter, yeah.
You would Mr. Hassan?
No, your lordship.
Who's Mr. Haq?
Your
Mr. T. Islam?
Yes, your lordship.
Yes. Can be disposed of.
Lordship will be taken up tomorrow.
Tomorrow.
My lords, the petitioners stand here claiming that they are here representing the job card holders. That is given in their annexure number 9, page 38 of the petition.
No, MS Arkul is representing whom?
Private respondent, your lordship, responding number 6.
Mozia Bibi.
Yes.
She's a very important respondent.
He's the VC holder.
She's the VC president now.
Holder, yeah. What's
Holder meaning? You have the brief with you?
Yes.
You file affidavit?
Your lordship, yes.
Have you filed affidavit? Yes. Yes. We'll have it next week then.
Your lordship, my submission is that kindly send an inquiry.
My lords, I'd object to that.
Yes.
My lordship, my lord, there is so many irregularities.
Because if she's sitting, then without hearing them, we suppose the orders of ousting, then see, yes,
My
1
lords,
week.
the writ will not stand because I am objecting to the fact that his claims are contested. That
Then we
he's-
can go ahead with the hearing.
No, my lords.
Yes, your lordship. Your lordship, your lordship kindly send for inquiry. Everything will come.
Everything will come.
Yes, your lordship.
Okay, after 1 week, we see whether it comes or not. Yes.
153. 153.
Hello.
Yes.
Your lordship, I had informed the respondent.
Inform them?
Yes.
Okay, after 2 weeks, yes. Here's your name?
D. Shadong, your lordship.
D. Shadong?
Yes, your lordship. Must apply, your lordship.
Madam, why reluctant to take up hearings?
My lords,
Pass post lunch.